That's what I hate. Sorry, Judge. Would you mind turning that on one more time?
I didn't turn it off, so
Good.
it really should be should be on.
Ooh. There we go. Thanks.
Okay. All right, we're back on record. No, we're not.
Back on record.
We're back on record. State of Indiana versus Elliahs Dorsey, defendant's present person by counsel, state by deputy prosecutors. We don't have all of the jurors yet. Once we do, will the defense be ready to proceed with argument?
Yes, Your Honor.
State?
Yes, Judge.
All right. Record should reflect that the court has consulted with the attorneys about the language that I will be giving to the jurors from the bench. I was concerned to make sure that I said things exactly right, but it is not what I'm going to say to the jury will not be an instruction, will not be sent back to the jury room. It'll just give them some idea as to the process we're going to be using. Does defense have any objection to the language that I've given to them?
No, Your Honor.
State?
No, Judge.
Okay. So what I will do is that I will start with this, and then I'll tell them that after talking with the attorneys, we've decided that both sides will have an opportunity to address the jury, and that the state will go first, the defense will go last. Both sides have the same amount of time. Then once the argument is done, then the court will send the jury back for deliberations. Any objection to that process, state?
No, Judge.
Defense?
No, Your Honor.
Okay, so we'll get started once we get all the jurors in, so we can go back off record.
Off record.
how much work you have put into this case up to this point. Thank you very much for your continuing dedication. I do want to tell you that I previously instructed you on the law of insanity, as well as the law relating to other aspects of this case. You should continue to consider all of the instructions that I've previously given to you. Please know there are no other legal instructions I can give you regarding insanity, and specifically on the law relating to whether someone appreciates the wrongfulness of their conduct at the time of the offense. This is ultimately your decision to make based on the law and the evidence given you in this case. I know when I had you fill out the document, you indicated that you would like some other case law regarding this particular issue. I do want to tell you, if you are given argument concerning prior case law regarding insanity, please know you are not bound by those decisions or the factual matters that might be contained within them. You may not draw an inference that because a particular fact situation produced a particular result in another case, that you must be guided to draw a similar conclusion. Again, your decision must be based on the law and the facts as you find them in this case. And you must disregard all information that you may receive from any other source. Having said that, the lawyers and I did meet earlier this morning and discussed the issues that you have raised and that are contained within the court's Roman numeral number 3. We have agreed that both sides will have an opportunity to address the subject matter with you. Both sides will be given 20 minutes to make argument. The state will go first. The defense then will finish up and have both sides have the same amount of time. Once they are done addressing you on the issue of wrongfulness, and again, their argument must be restricted to the area that you asked about, the wrongfulness of the ability of someone to appreciate wrongfulness of conduct. And so that will be the exclusive area that they will be addressing. Once they are done with that, then I will send you back for further deliberations. With that, State of Indiana, are you ready to proceed?
I am, Judge.
You may.
Thank you. Good morning, everyone. In your note earlier this morning, you requested case law on the issue of how to tell if somebody knows right from wrong. So what I have from you right here is Goodwin v. State. This is a case from 1883. It's been cited by Indiana courts as recently as 2020, and I am assuming that as you sit there and look at it, you are finding it to be less than helpful. And I understand. You are looking for an easy test to plug our facts into and come to an answer. And I'm sorry, that's just not the case. Prelim 19 says that you are the exclusive judge of the evidence. It is a terrible thing to sit in judgment. I understand that at this point, again, it is your burden to bear. But the good news is we trust you. Under the law of the state of Indiana, you alone are the judge here. You have the power. And with that power, the respect that we all show you, if you've noticed, when you walk in and out, everyone else in the room stands up. That's because we recognize that you are in control. You alone make the decision. The doctors who evaluate the defendant, they don't sign the verdict forms. Detective Prater, who took the defendant's confession, he doesn't sign the verdict form. Aisha Brown, who still bears the scars of when the defendant gunned her down, doesn't sign the verdict form. That is your job, and you're all alone. Now, even if there is no clear test, there is some guidance that you can take from the case law on the issue determining whether the defendant knew right from wrong. So first off, case law is clear, intoxication is not an excuse. Remember, the two doctors who testified, who were not paid by the defense, agreed that drugs had to have played a role in the defendant's behavior on April 9th. You can consider that. You can also consider the lack of a mental health history on the defendant's behalf. So the fact that he was never diagnosed, never treated, never medicated, never hospitalized, never institutionalized, he never reported any prior delusions, you can consider that. I would submit to you that you can also consider the fact that since April 9th, everyone is in agreement that these symptoms have receded without medication, without treatment, without hospitalization. You can consider that. Now, the expert testimony is advisory on the issue of sanity. You don't just rubber stamp the conclusions of a doctor. You can disregard it if there's conflicting evidence. Maybe, for instance, the doctors disagree with each other. Maybe the doctors interpret the evidence in a way that totally conflicts with your common sense interpretation. You can disregard it. You can also discredit it entirely if you don't believe it. You have that power. Now, there's another case, Barcroft v. State, it's Indiana Supreme Court from 2018, and there the Supreme Court said, conflicting diagnoses could reasonably have deprived the expert opinions of credibility in the eyes of the fact finder. So basically, the fact finder could look at it and say, hey, these expert opinions are totally different, therefore I don't find them credible. Interesting about Barcroft, the experts that conflicted in that case, Dr. Calloway, Dr. Parker. Now, this is sort of encapsulated in the instructions that you got, but you can consider, aside from the expert testimony, what the defendant did before, during, and after the crime to infer their mental state. Dr. Calloway was really clear that that is the best evidence. You want to go back in time, look at what was happening and what was said. That's what you want to consider. That's what the case law tells you to look at. So what do we know about this case? Well, everybody agrees that the defendant was not delusional. He didn't know, he was able to tell right from wrong prior to April 9th. That's the time that we're focusing on. Nobody is alleging that he's insane under the law prior to that. So it's April 9th that we're worried about. Now, what happens that day? First off, he doesn't leave the apartment. He gives a lot of conflicting reasons why, tells a lot of different stories, but he doesn't leave even though he clearly has the chance. He also refrains from harming Aisha. Now that's his story, that she was such a threat to his safety, he had to use deadly force to protect himself from her. Well, the first time she takes a gun away from him, the first time she disarms him, he doesn't hurt her. Then she challenges him to do it, to shoot her. She basically calls him a coward to his face, and he chooses not to hurt her because in that moment he knew right from wrong. If she's such a threat, why didn't he eliminate that threat beforehand? Because he knows right from wrong. Then why suddenly does he think that Aisha has sent people to harm? So remember, at first he's generally paranoid. Like I said, he met ill. He thinks that his family's in danger, he thinks that he's in danger, but he's not saying at first that it's Aisha. Even if you go back and you look at that first 911 call, he says, have you ever feel like somebody's been trying to kill you all day? At no point does he say, hey, help me, I'm trapped in this apartment with this girl who wants me dead. He's not yet come up with this story that, oh, it's Aisha that I need to protect myself from. Never tells that the 911 dispatcher. What happened though? Why might he think that Aisha suddenly has a problem with him? Maybe it's because for the first time, he got violent with a woman, he grabbed her, and he bloodied her face. He knows the difference between right and wrong, and he has suddenly recognized that he is on the wrong side of that line. Think about the way that he shoots the gun. He's holding the most powerful weapon in the apartment. He waits for the knock at the door. It is a perfect ambush. Now, we heard yesterday, well, he didn't fire directly into the door. He fired where he was standing when he heard a knock. After he keeps Aisha from opening the door, he fires from where he's standing. To say that he didn't fire directly into the door is absurd. He fired full field of fire into a hallway where he knew it was occupied. Didn't fire directly into the door. He fired directly into Breann Leath's head because he was intending to cut down whoever was out there. Remember from voir dire the idea of, well, somebody believes that there are assassins in the attic. He's not firing wildly at assassins in the attic. He is putting rounds on target where he wants them to go. And then he shoots Aisha. Think about it. I said before, he's such a threat, or she's such a threat, but he doesn't try to neutralize that threat beforehand. When he shoots Aisha, she is not a threat to his safety. She is the only eyewitness to a murder. A murder that he knew was wrong, in a murder that he is trying to cover up. But then he surrenders when he realizes that she's on the phone with 911 and there are more officers on scene. Now, a madman would have stayed there in the hallway and banged it out with the officers with the guns that he had left in that high-capacity magazine. An insane person would have used that tactical advantage to fire down on these assassins as they're coming up the stairs. He doesn't. He retreats to the apartment. He makes sure to tell the 911 dispatcher that he is surrendering. He makes sure to distance the weapon from himself. And he makes sure to put himself in a position where the police are less likely to harm him because he understands that he has done wrong. Think about the statements after. I'm sorry. Did she have a family? Are other people hurt? The question is, did he know what he was doing was wrong? Not did he know what crime he was committing? Not what law was he breaking? I'm sure none of you understood the exact elements of attempted murder before you sat down in this jury box last week. You still all knew that it was wrong to fire bullets through a wall into an occupied hallway. Now, the judge just gave you some advice that the case law in a particular case is not as important as what you know about this case. This case, the facts of this case are what's important. The defense yesterday talked about a case called Galloway. They were trying to emphasize that you should consider what happened before and after a crime is less important than what happened in the moment. Gregory Galloway was diagnosed as being bipolar in 1989. Beginning in 2001, those symptoms got worse. In 2004, 2005, and 2007, he was repeatedly hospitalized against his will for mental health treatment. On October 26th of 2007, he began believing that his father was telepathically telling him to kill his grandmother. A grandmother that he had previously taken a gun and said he had to kill because she was Satan and he was Jesus. In October of 2007, he hears these voices in his head. He jumps on his grandmother's chest and he stabs her repeatedly while saying, I have to do this because you're the devil. That's why we want you to focus on the fact of this case. Every case is different, but we want you to bring your judgment and your common sense to this case and the facts that are before you today. When you came here last Monday, you knew the difference between right and wrong. You also knew how to tell if somebody else knew the difference between right and wrong. Because you have common sense, you have judgment. So I am asking you to call on your conscience, to call on your common sense, to call on your judgment. Recognize that you know the difference between right and wrong, and recognize that on April 9th, 2020, so did the defendant. And for that reason, you should find him responsible. Thank you.
Thank you, Mr. Beach. Ladies and gentlemen, that concludes the state's argument to you. Ms. Martin, does the defense wish to make an argument?
Yes, Your Honor.
You may.
Comes down to this one issue. Was Elliahs insane at the time, at the moment of these alleged crimes? And he was. He's legally insane, and therefore he is legally not responsible by reason of insanity. So the state just now got up and said, well, he has this drug use, and gave you case law that voluntary intoxication can't be justification for a mental disease, or that there's not a long history, a documented history of mental health issues, and gave you case law supporting that. But that's not the issue, because there is no dispute none from anybody that Elliahs was suffering from a mental disease or defect. Dr. Golden told you that. Dr. Garker told you that. Dr. Parker told you that. Dr. Calloway told you that. Then experts that the court ordered. Dr. Ross came in and told you that. Dr. Trevette told you that. And the government told you that yesterday because they said, find him guilty but mentally ill. So that case law that the state just cited, they're contradicting themselves, and they're contradicting every single witness. That's not in dispute. And in fact, you all didn't send out a note about that. It was about being able to appreciate the wrongfulness of his conduct. Did that mental disease or defect render Elliahs unable to appreciate the wrongfulness of his conduct? And actually, there's very little discrepancy between people about that. Dr. Golden said, yes, he could not at that time appreciate the wrongfulness of his conduct. Dr. Garker, at the moment this is happening, because the mental disease or defect, he did not appreciate the wrongfulness of his conduct. Dr. Parker, he did not appreciate the wrongfulness of his conduct. Dr. Calloway, she agreed, he did not appreciate it. And the court's Dr. Ross, he did not appreciate the wrongfulness of his conduct. And the state could have hired an expert if they wanted to dispute that, but they didn't. There's only one person, one expert, who, even though she said, yes, he's suffering from a mental disease or defect, said she thought that at the time that he could appreciate the wrongfulness of his conduct. She's from a different state and they have a different statute. You guys asked her questions about how many times have you found someone couldn't appreciate the wrongfulness. And she couldn't even talk about the Indiana statute. She said, well, I mainly work in Kentucky and they have, did they understand the criminality? And someone asked, how many times have you found someone legally insane in Indiana? And she said, well, I've testified in Indiana in federal court. Well, federal court is a different court. They have different standards, just like Indiana and Kentucky have different standards. She couldn't name you one time that she's ever found anybody legally insane under Indiana statute. She really couldn't even say that she's ever evaluated anyone under the state of Indiana statute. And she is the sole expert that said that he appreciated the wrongfulness. Calloway, Dr. Calloway, is regularly appointed in Indiana, understands the Indiana statutes, the Indiana law. She is regularly appointed by the court, by this court, to examine people for competency or insanity. And she said that there's a very small percentage of the time when she actually found someone insane. But in this case, she did. In this case, he couldn't appreciate the wrongfulness. Dr. Ross, not hired by us, hired by the court, doesn't usually practice in Marion County, but does in Indiana and is very familiar with the Indiana statute, said under the Indiana statute, Elliahs was legally insane. He could not appreciate the wrongfulness of his conduct. And then there's Dr. George Parker. He is the guy in Indiana. He teaches at the IU School of Medicine. He teaches at IU McKinney School of Law. If you want an answer about something that has law and psychiatry, law and medicine coming together, it's Dr. George Parker. And he is regularly testifying and being appointed by court after court throughout Indiana, including this court. And he said Elliahs could not appreciate the wrongfulness of his conduct. He was literally insane. So the state would to use some passages from Barcroft. But what Barcroft says is that psychiatrists, psychologists, they have the training, they have the expertise to determine whether someone can appreciate the wrongfulness. Their opinions are very helpful to fact finders because they know what to look for. They are specifically trained. And all of you in your questionnaires, we asked you, what do you think about experts? And time again, you all said they are experts. I want to hear from them. I want to know what they have to say. That would be helpful. And Barcroft decision says, yeah, it is helpful. They are helpful. Make the decision. And so you will have to decide for yourselves. But these experts know the law. They've seen patient after patient after patient. And you should consider what they have to say, all of the experts, but particularly ones that know the Indiana statute, the Indiana threshold. And then Galloway, that the state just quoted, says that Indiana does recognize temporary insanity. What happens before or after? What it says, the law thus allows for the possibility that the defendant is legally insane at the time of the crime, but compos mentis immediately before, immediately after. Compos mentis means he was sane. He did some sane things before and after. But Indiana allows that you may be temporarily not sane. So, what are some ways that we know that he didn't appreciate the wrongfulness of his conduct? He went to Bianca's house and jeopardized her and her family's health during COVID. This is a woman he loved. This is a family that loved him, but he kept doing that. He's not getting, you could kill these people in this pandemic. He's not appreciating that it was wrong to keep coming back. When there's a knock at the door, he says, that ain't the police. He's not appreciating the wrongfulness of what he's about to do. He thinks he is trying to save himself, trying to scare off a would-be attacker. He keeps her back so that she can't go get Aisha. Open that door for his assassin. He thinks when he hears that knock on the door and she starts to go, well, she just called someone to come get him. They're gonna get him. And he wants to hold her back because she's done let through that doorway whoever it was that she asked to come kill him. How do we know he didn't appreciate the wrongfulness of his conduct? After he is shot through the door, after he has shot Aisha, after she is laying on the ground bleeding, he goes and takes her phone and says, "You think you're slick." He still thought she was going to go get someone to kill him. "You think you're slick." He takes that phone away so she can't. Now, he didn't unload his gun into her. She's still laying there talking, alive. So there's no specific intent to kill her, but he really did try to keep her from getting out of that apartment building because he thought she was going to get someone to kill him. How do we know he didn't appreciate the wrongfulness of his conduct at the time it happened? Because he shot through that door, and when the police are asking him, "Do you know how far those bullets travel?" It hits him. "Oh my God, is anybody else hurt?" When he's shooting, this guy that has gone to the gun range and knows guns, he didn't think about that because he's not thinking about the wrongfulness of his conduct at that point. But when the detective says, "Do you know how far those bullets can go?" Oh my God, did anyone else get hurt? And how do we know he didn't appreciate the wrongfulness of his conduct? Well, the state just got up here and told you he was waiting for the knock at the door so he could unleash his hail of bullets. If her boss let her go a little bit earlier, if traffic had been a little bit different, that knock at the door would have been his mother. They didn't say police. He didn't know he was shooting police or shooting at police. He just knew someone knocked. And but for a twist of fate, it would have been his mom. Now, we have the burden, but it's not what you heard about at the beginning of the case, this strict and heavy burden beyond any reasonable doubt. It's a preponderance of the evidence. It's different. Is it more likely than not? Was it more likely or not that he was insane at the time? Not beyond a reasonable doubt, just more likely than not. So we talked to you in voir dire about the arsonist that burned down a house because he thought there were ninja assassins inside that could hurt the community. And we talked about if that's why he's doing it, if that's what's in his head, he's thinking he's saving somebody, the community, himself, whoever, if that's why he committed that arson, he's not responsible by reason of insanity. Because at the time he lit that fire, even though it might have the same devastating consequences as just the arsonist that wanted to collect some insurance money, this guy did it for a different reason. And you all understood that in voir dire. I told you in opening this wouldn't be easy. And you all know that. Midnight, 1, 2 a.m. last night, you all knew that. But you knew it before then. You knew it when you saw those autopsy photos. You knew it when you saw families from both sides dealing with this. State is absolutely right. Officer Leath was there to serve and protect. I said in opening, she came to help, not hurt Elliahs. I know that. You know that. Everybody in this gallery knows that. Elliahs knows that. Right now. But right now isn't what matters. What matters is what happened in that moment, in his mind, that day on April 9th when he shot through that door. And then, he didn't think that knock was there to help him. He thought that knock was there to kill him. You know his character. He coached for the police athletic league. He loved to coach kids. And in fact, if you just listen to his police statement, everything is yes, sir, please, no, thank you, sir. And even the statement that just grabs you when he talks about, I saw the dead officer. A lot of people, just in that moment, would say, I saw the dead cop. But Elliahs
You have 2
Dorsey,
minutes.
thank you. Elliahs Dorsey, after he's had these hours of what is going on, someone's trying to kill me. How did I get that wrong? He realizes he killed an officer. He doesn't use the word cop because that's not who he is. That's who he is. And on April 9th of 2020, who he was a legally insane man who tragically killed a hero. And it's not easy. But do the right thing and find him not responsible by reason of insanity.
All right, ladies and gentlemen, that completes the supplemental argument and information from both sides. The court now will direct you to go back and continue with your deliberations. Good luck, and all rise. Please be seated. Reflect jurors have left the room. Anything administratively from either side, we have your phone numbers. Same procedure as we did before. Anything further for the record, defense?
No, Your Honor.
State?
No, Judge.
All right, we'll let you know when we hear anything from the jurors then. That will be in a recess.
Off record.